following program on Other Derana 24 is classified for general audience. It is intended for all ages. It contains little or no violence, no strong language, and little or no sexual dialogue or situations.
Tonight, we discuss the laws surrounding extrajudicial killings in Sri Lanka. Is the current legal framework equipped to handle such cases efficiently and justly? A very good evening and thank you for joining us on yet another episode of Law, Land and Liberty, where we bring to you key legal concepts and break it down for the layman. Tonight's topic is something that has been making the rounds in public media as well, and that's on extrajudicial killings and the laws surrounding it and what we can see in the legal sphere when it comes to preventing such killings from taking place. And to talk about this, we have someone that's not a new face on the show and is very well equipped to do so, and that is President's Counsel Silva, attorney at law. Sir, thank you very much for taking the time once again to step into our studios to really help us explain and understand this very complicated topic. Before we get into any of the specifics relating to the discussion, here's a bit of a breakdown. We're going to talk about the basics first, where the law lies when it comes to extrajudicial killings. Next, we'll be talking about the current context and what we've been seeing in recent times. And finally, we'll be talking about what we can see moving forward in Sri Lanka's legal sphere relating to extrajudicial killings. All right, well, without any further ado, let's get right into the discussion. Thanks again, sir, for stepping into our studios again. Of course, you're not a new face on the show, so we can expect quite a lot of explanation and understanding for the layman as well, relating to how the law around this area works, specifically when it comes to the current context as well. But before we get into the nuances, I think it's important for us to start with a bit of a basic introduction onto what extrajudicial killings really is. Could you please start us off by helping us understand what constitutes as an extrajudicial killing in Sri Lanka's laws?
In a situation like this, we have to explain it according to our constitution. Constitution has clearly identified police arrest. That is a separate article had been there, that is Article 13 of the Constitution, present Constitution, 1978 Constitution, there, where it is that particular article completely states about the police arrest and the rights of the person who had been in custody of the police. So they say, according to that, every person has a right to defend himself, and once he is being arrested, he should be looked after till the person is being produced before the court. So that is the fundamental right of a person, that once I have been taken into custody, that does not mean that I have done a wrong thing. I have been asked to come, or I have been arrested by the police on suspicion. So he is being called as a suspect, not an accused. People may say various things, but according to our law, it is very clear that a person is being taken into custody, we called as a suspect, till the investigations are over and finally the police or the Attorney General thinks that he should be charged. It is up to the police to look after him as a suspect. Once the police investigations are over, he should be produced before the magistrate. That depends on the circumstances of the case. Sometimes 24 hours. If they want more period, they can ask the magistrate by producing him there and ask the magistrate to we want some more time, that is, they will be given 48 hours. So likewise, they can have their investigation done. For the purpose of investigation, if they are going with the suspect to another place, they should be very careful. And now we have guidelines, although there are guidelines, but they are not adhered to that. So once they go there out and then kill a person, and if they cannot give an explanation for that, it should be called as extrajudicial killing or murders. So for that purpose, immediately we can't say that, but on the face of it, we can see what actually happened. But in the meantime, police should ask the magistrate to have the inquest. Once the inquest is finally finished, the magistrate will decide whether this is a murder case or else it's a case where the police have acted according to the law. So if that is so, then there won't be any problem. Otherwise, if they have gone beyond that or violated the fundamental rights of that person and killed that person, then they should be punished by court of law.
Exactly. I think I'd like to ask you in relation to that, how exactly extrajudicial killings are differentiated from lawful state actions, example military engagements or maybe shootings by police. Could you please explain to us how much of a distinct difference extrajudicial killings has, sir?
Now, when the police try to arrest a person, if he is not adhere to law or adhere to their word, and then if they run away or they try to do something to the police officers, they can kill the person. They can shoot or they can kill the person with a weapon, and we can't say it's wrong because that person not being arrested, but the police have tried to arrest him, but he avoided, and then because of that they have to use the power. The power also defined in a particular way, but if he has a weapon in his hand and try to do harmful act to the people who are going to arrest him, then they can use their weapons and then kill a person. That is not a wrong thing. But once he is being arrested, it should be very careful. They should be very careful about that. When the person is in custody, the police have to look after, as I mentioned earlier, the police should look after according to the frame of the law. Otherwise, they can't just go and ask the person to show something, or the person will say that I will show the weapons or any other article pertaining to the crime, I will show, and when they go with him to trace that article, then they say that that person tried to shoot or evade arrest. So that is the issue there. How are they going to take him out from the custody? So that particular part is being investigated, and then there are laws according to that particular circulars they have to act upon. Otherwise, they are violating the fundamental of that particular person.
Speaking of which, sir, I'd like to ask you specifically that you mentioned that there are specific laws. Can you walk us through some of the key laws that are in place in Sri Lanka's legislature to prohibit extrajudicial killings, and how exactly they are aligned with international human rights standards?
Now, when we discuss this matter, as I mentioned to you, we have to adhere to Article 13. It is very clear that when they do something against the article, then they are violating the fundamental rights of the particular person. So anybody grievant of that particular act, and then they can go there. The person, not that person himself or his wife or any relative, some other person also can do. If he is having any interest about that suspect, then he can file a fundamental right case. Earlier it was not the law. Earlier he should file a case within 30 days. Now it has been changed, and the Supreme Court has decided to accept, even if you go beyond that, if they have reported to the Human Rights Commission in Sri Lanka, and then that 30-day period is not a mandatory requirement, and then he himself is not in a position to file a case, but apart from that, any relative who is interested in filing a fundamental right case, he can do so. That is one part of that. So merely because the fundamental right case is being there, that does not mean that the person who is responsible or people who are responsible for that extrajudicial killing should not be punished. So they should be punished according to law of the country. That is the penal code is there. It is like a normal murder case where they say firstly the magistrate after the inquest will decide whether it's a murder case or not. So then he will give an order. Accordingly, then the IBXX are being prepared and send it across to the Honorable Attorney General. Honorable Attorney General will file an indictment according to Penal Code as well as ICCPR Act. So those are the areas governed when they kill a person not according to law.
Exactly. So we see that there are safety nets in place, and there's avenues that one can pursue when faced with something like extrajudicial killings and also human rights violations. Specifically, we can have FR petitions for that as well. Moving on, so specifically, there is the fact that the right to life is not specifically mentioned in our constitution. So when it comes to legislation, legal action taken against extrajudicial killings, how does that play into it?
Sorry?
When we have the issue of how Sri Lanka's constitution does not explicitly mention a right to life. So how exactly does that play into the impact that the legal action that we can take against extrajudicial killings are affected, or is it not?
Not. Because now, as I mentioned to you, though it is clearly not mentioned about, as you said, the right to life, but that impliedly it says that a person has all the benefit till he is being convicted. So that it is very clear, every person shall be presumed innocent until he is proved guilty. So that is the norm. So that is being covered in Article 13. Accordingly, that article goes further and say when you are detain a person, the police should look after them very carefully, and if they want to investigate matter, they have to record the statements and inform the higher authorities and take precautions while they are going out. Now, earlier there were no particular circulars issued, though there was an understanding, but recent judgment delivered in 2023, that is 3rd of February 2023, the famous judgment where the Supreme Court in that particular judgment has stated to police, this is a serious thing and we can't tolerate further. It's been happening right through, and you have to prepare the guidelines or the circulars according to what we want, and then prepare the guidelines and send it across to us and all to apart from thereafter to all the police station. So accordingly, the IG earlier 25th of March 2023, IG in consultation with Director Legal, DIG Ruwan Gunasekara, he has prepared, IG Vikramatne, those days the PD Vikramatne, he has prepared comprehensive circulars explaining everything, not only the guidelines, they have explained the particular case and then what the Supreme Court judges have decided on them. Especially Bhuvaneka Alavihare, the Supreme Court judge, has gone to further implications of this particular act, and then he has stated if you are not adhere to the particular laws and then do something like that, you are tarnishing the image of the police. So don't do that, and for that purpose, we will direct you to have this particular circular. So then they have prepared the guidelines and do it. Even that, unfortunately, though this was published in 2023, recent killing was the classic example for for extrajudicial killing. So that is being happening. So what we are emphasizing is you can't tolerate that. Even the present government, the president was vehemently objecting for that type of act when he was in parliament as a member of parliament in the opposition. He has stated this particular act is we can't tolerate this one. So he has made that speech right through in the parliament. Then now he has the power. It is up to him to say that police should take firm action not to do those things. After doing that, if we are going for fundamental right case and filing a case is not the thing that the people want. Now, look at this case. This particular case, as I mentioned to you, this incident had taken place in 2008. After 15 years, only the judgment came. So the people, every party has to wait till 15 years to see the justice. So then we can't tolerate that. That is why we say the police should take firm action against those officers who are not going to adhere to these areas. But at the same time, the police should take necessary action and file cases against these people after consulting with the Honorable Attorney General.
There has to be a proactive approach in order to curb such abuses of power occurring in the police system as well, and specifically when it comes to extrajudicial killings, the fact that you mentioned we have had steps taken to try and prevent and curb it, but we still in present day see the lapses and lacunas to this day. I think we have to get into the current context as well when it comes to aggrieved parties and also the deliverance of justice, as you mentioned. So there's a big delay there. So before we get into any of the specifics related to that, let's take a very short commercial break. You're watching Law, Land and Liberty. We'll be right back after this. Welcome back to Law, Land and Liberty. We're in conversation with President's Counsel Silva. So thank you very much once again for the previous segment. I believe we covered a bit of the basic ground and also a little bit of the current context as well when it comes to extrajudicial killing specifically. Of course, we can't delve into all the police powers at the moment and what the issue is with the entire system in itself, as we have seen. But I'd like to direct our attention to the aggrieved parties, and apart from the perpetrators, how exactly, what legal avenues do we see that exist for victims' families in order to seek justice when such an extrajudicial killing occurs? As you mentioned previously, a certain family had to wait for a landmark judgment for 15 years. So what legal avenues are there, sir?
Well, that is why we say the authorities must take firm action and show to the aggrieved party that we are supporting your grievance and we are helping you to come out with that. Now, the person has been killed, that's a different point. You can't get their life again. But at the same time, the perpetrators should be punished. So that punishment is not coming forward is the issue. So it get delayed. So by delaying that, or because of the delay, people will think we are not getting the justice. So that aspect has to be changed. So for that purpose, Victim Protection Act is there. So immediately what they should do is they should go and inform the Human Rights Commission. That is the best way they can do. All the telephone numbers are available, and then they can report it immediately what actually happened. Now, if a person is being taken into custody, the aggrieved party or the home people should know that once he is being taken into custody, it's a difficult task. What will happen to him next is the issue. Will he come home, or will he go to remand prison, or his life is in danger. So for that purpose, they should go and report to Human Rights Commission. But unfortunately, Human Rights Commission is not in a position to do whatever things that are they should do, because they don't have much powers. But they can inform the authorities. This person has been taken into custody, you have to be very careful. And they can visit the particular police station or the place where he had been detained. Then the people, the aggrieved people, aggrieved party will know that something happening and our relative is safe. Thereafter, what they can do is, if they are in fear, they can go to court, and then they can give necessary instructions to lawyers. If they don't have money, then they can go to Legal Aid Commission and ask for help. Apart from that, Victims Protection Act is also there. There's a special bureau for that, and they can get the help of that, for those people. They straight away they can write to the Honorable Attorney General also what actually happened, and then the Attorney General will give necessary instructions to the police. So that is how you have to be very careful, and immediately, spontaneously you have to take action. If you wait till everything is being done, then it's very unfortunate. You can't go further because of the delay. So immediate action, we should give more details to them and say that please take immediate action once he is being arrested. If you think that his life is in danger, you can go to courts and get an order. Also, not to take him as and when the police are going to do, and then prohibiting them to take out without getting permission from higher authorities. So that factor, of course, can be done by way of a writ application. That is also there, and immediately they can file a fundamental right application also if he is being taken unlawfully into custody. So once he is being taken into custody, it is the mandatory requirement that person should know what would be his charge. Why I have been taken into custody. That is the duty of the police. So I don't know whether most of the police officers are doing that or not. Some of the police officers, they are doing a great job, but because of these, some police officers, they think that they can do whatever they want and get out of that. So that because of those police officers, the image of the police is degrading and they're going down. So that factor we should address immediately.
So I'd like to continue on that note now. There are multiple avenues that are available for aggrieved parties to seek justice related to extrajudicial killings, specifically for the victims' families as well. And speaking on that note, I'd like to ask you about what we have seen in our legal history when it comes to the significant legal cases related to extrajudicial killings. Could you please give us some knowledge on some of those cases?
Yeah, now we can say that Premawati Manamperi's matter case, the famous case, Vijay Surya versus the state, that was in 1977 in LR it was reported. So in that case, they have identified and stated that the authorities, once they take a person into custody, they can't kill a person without judicial order. So that means that you have to produce him before court, and after trial, he has every right to defend by himself or by an attorney at law. And thereafter, if he is being convicted in a high court case, if he is not satisfied, he can go to court of appeal. And on legal issues, he can go to Supreme Court as well. So finally, we can say that he is a culprit or a murderer or a robber, like things that we can say only after the law enforcement authorities finally produce him, and then the court will decide what steps they should take according to the law. So if it is a murder case, then the punishment would be death. but in our country it's not being implemented. But final judgment would be that he should be hanged. So that is the case, even if he is a murderer or any person who has a lot of cases with him, the police can't take action against him without proper judicial order. So that is the reason that they discuss about that. And then another case, Lama Hevage Lal, that he was a deceased, and against the Sidhu police, there, as you mentioned, right to life is being discussed. And Justice Bandanayaka has clearly stated the person has all the right till he is being convicted by court of law. Up to that point, the police are not in a position to do whatever they want. They can inform the court what step they should take, and then get the assistance of court, and then do the investigation. Once the investigations are over, they can't kill the person, or while the investigations are over, while the investigations are going on, they can't kill the person. They have to adhere to the law of this country and then produce him before the court. Even if they are going ahead, and then if they want to take that person out of the remand custody, there is a provision. They have to get permission from the magistrate, and then once the magistrate is given the order, they can take and can, after that, handed over to the remand prison. While he was in custody also, now according to latest circular, they can't just take a person out of the police station. Though those are discussed in the right to life is being discussed is Lama Hevage Lal case. And then finally, as I mentioned, Fatima Shamila versus Save Island Police is the main case or recent case where the Supreme Court has gone full length, and then they have given the authorities to make necessary guidelines, and now it's been there. So that is how it goes, and we have all the material with us. Only thing is whether we are in a position, or the police are in a position to adhere to those guidelines or not is the issue. So I think police should take immediate action and change the attitudes of the so-called police officers. Otherwise, even a lot of laws are there. You can't do justice according to the laws.
Exactly. Despite there being legislation, we need to see enforcement in order to have a proper carrying out of justice in our system specifically.
Apart from that, from 1994 onwards, the ICCPR Act has come into power. Now, it is being discussed in 1984. We also party to that particular convention, and then we went there and agreed to prepare necessary laws in our country. Accordingly, we have waited till 1990 for 10 years and passed this ICCPR Act. So now that's also there to strengthen the rights of the person. So that is also can be taken into consideration when we are discussing these matters.
Exactly. And moving on, sir, when you mentioned the ICCPR as well, when it comes to the humanitarian effects that we have seen as well, specifically when it comes to the Human Rights Commission, you mentioned earlier about the Human Rights Commission also and what they can do. Can you please help us delve a little bit deeper into that area, specifically the effectiveness of the Human Rights Commission in investigating and also addressing cases like extrajudicial killings in Sri Lanka?
Only thing is, before that killing is being done, it is up to the parties, the relatives or the aggrieved parties, they should immediately, as I mentioned to you, immediately, promptly, they should go to the Human Rights Commission. Now we all know that particular commission is there, so we have to take immediate action and report them. Then they will immediately contact the relevant authorities, and whether he is there or not, they will find out, and then they will visit that particular police station or the place where that person is being detained, and then do a lot of things accordingly what he wants. So if he wants to have a lawyer, then they can inform the relatives that you immediately retain a lawyer and send him there. And then the necessary guidelines also. If there is a torture or any other inhuman act is being done, then they call the necessary authorities for an inquiry. And then the aggrieved party also informed, and then they will have a inquiry about it. But as I told you, they can't take action immediately because they can report to the Supreme Court once the what actually happened and what is their opinion about those things. They can report, but unfortunately they can do much of things. They can give compensation. If you want to get compensation, you have to file a fundamental right case. In that fundamental right case, it has been decided the person who had been aggrieved has all the right to get compensation from the government, not only from the government, but individuals as well.
Exactly. I mean, the Human Rights Commission, while it doesn't have enforcement abilities, but it can still be some sort of an overwatch body in order to ensure there's some sort of accountability as well, or some sort of external support to the aggrieved parties and also the concerned parties of the families relating to the individuals that may face a threat of extrajudicial killings within the police system. Moving on, so I think that's a good leeway for me to get a clarification from you relating to the oversight aspect. Of course, now, do we have independent oversight mechanisms when it comes to Sri Lanka's police and law enforcement system, or do we not at all?
No, as I mentioned to you, in 1984, this particular convention was there, and a lot of countries agreed that this is a torture and other cruel, inhuman or degrading treatment should be disregard, and then it should be adhered to immediately, and then you must prepare laws according to the country of your particular areas. That's why we have prepared this ICCPR that shows that we have some sort of mechanism, not only penal code, this 22 of 1994 Act itself gives power to the authorities to take immediate action with regard to these particular people. And it is very clearly stated that a person being aggrieved should be looked after, and then he should be given the opportunity to file cases and then punish these people by court of law.
Exactly. We see that there is, of course, some sort of oversight, but technically speaking, the police, the law enforcement authorities do not have a different responsibility body. Of course, they have to cultivate that environment within its own systems.
That's right. So that is why this particular circular came into operation. But still, they have not gone into these particulars very seriously. That is why we saw the recent killing.
Exactly. I think in relation to the recent killing as well, I'd like to ask you about what we have seen as recent legal developments when it comes to the areas surrounding extrajudicial killings in Sri Lanka. Could you please give us a little bit of insights?
No, only thing is now, as I mentioned to you, we have a lot of areas covered by law, and then whether we are going to adhere to that, as for example, the confession also. Now, 1895, yes. When we are preparing our Evidence Act, evidence as a law, the British person who drafted this particular law, Evidence Act, in 1895, clearly stated that the confessions given to police officers, whether they are in custody or they are in around the police area, police detention, so then they can't use that confession.
Not admissible.
In court of law. So though that is there, we see the police will give a lot of publicity by producing that confession to the media, and then to show that this is a person who has a lot of criminal records, and he has done a lot of damage to the society, and then people will think even that extrajudicial killing was done, is it okay because he is a culprit and he is a criminal and he has a lot of cases, he has ruined most of the people's life. So that is, because of that, we are not bothered. So that is not the issue. In a country like this, we have good laws, and then our justice system is very good. So because of that, we say that police, please adhere to these rules and regulations, and then do the necessary investigation properly and produce him before court. Then the court will decide whether this case is being proved beyond reasonable doubt, and if it is so, then he will be convicted. So then we see the result in a judicial manner, and then we know that justice being done to everybody, that the aggrieved party will also see that justice is being done. Now furthermore, now in our country, the aggrieved party being called to courthouses when the pre-trial stage is being done. So that is also new development in our law. The aggrieved people, not the suspect or the accused party, but some people are being aggrieved because of the act done by that culprit, and those people are being called to the courthouse to see what is happening to that case. So that is the justice system in this country. So the police should know to adhere to that and do their best for investigation purpose. If they properly investigate the matter and produce necessary good evidence before court, nobody can challenge it, and ultimate result would be that person will be convicted.
Exactly, and there's also more for us to get into when it comes to the confession and the forced confession, the coerced confession aspect as well, specifically about the fact that how it's not admissible in court, but we still see it happening to this day. In order for the public, the court of public opinion will give us a judgment before the
That's
actual
right.
court of law gives us any sort of justice. I think we have to get into those specifics and also about what we can see moving forward in the future in relation to extrajudicial killings and maybe violence in the law enforcement system. But before we get into any of those specifics, let's take a very short commercial break. You're watching Law, Land and Liberty. We'll be right back with the final segment. Welcome back to Law, Land and Liberty. We're in our final segment in discussion surrounding extrajudicial killings and the laws related to that as well. And we just got into a very interesting area, which is coerced confessions and police confessions. So you mentioned how it's not legally admissible at all, but we still see it happening. Specifically in relation to that, the reports of torture or maybe violence used in order to extract confessions within the law enforcement system is a little concerning, of course. There are specific legal remedies for this, right, sir? Is there any sort of specific area that we can look to at the law that says that this is strictly not okay and completely prohibited?
Completely prohibited according to normal law. Now, in our country, the penal code is there and the evidence ordinance is also there. Under penal code, if you are going to prove a case, confession cannot be used. It is clearly stated in the evidence ordinance. But Prevention of Terrorism Act and emergency laws, they provide the police to have that confession recorded by ASP above. Not only a normal police officer, but ASP above is going to record a statement, and if it is recorded without any harmful act or threaten, promise, or any inhuman, degrading things are there. If that is not there, then it can be accepted. But it is there, of course, if a confession is being given to ASP or above, the accused should prove that it is not a voluntary statement, voluntary confession. For that purpose, section 24 of the evidence ordinance is very important, and it is very clearly say it is not beyond reasonable doubt or balance of probability. If it sees to court, that is the thing that they have used, that particular word, sees to court that the confession was obtained in an illegal manner, then it will be rejected. Apart from that, the other confession which normally day-to-day life we see are totally prohibited, and it is illegal to have that confessions published by the police. So what they do is they arrest a person, somehow they record a confession, whether it's voluntary or not is illegal, and then they give it to the media. The media personnel also should know it is wrong to have those confessions published and inform the people about what he has stated. So this is a very popular thing that most of the police officers, they think to show that they have done some duty, they arrest a person, whether he has done it or not, they record a confession and then give it to the media. Then people will think, here, now he has confessed everything. So what more we want? And why are we going to court and then go for prolonged trial? And finally, he will be acquitted. So then the people will think, oh, what is the meaning of justice? So the people always think the court or the legal system in this country do justice to people. So if you are doing that type of thing by publishing those confessions, which are not necessary at all, and then it will show that people will come to conclusion that particular system is not in a good proper way of handling those cases, because most of the cases finally the accused will be acquitted. So accused will be acquitted not only because of the confession, he will be acquitted because the evidence that are being produced by the police are not sufficient to prove it beyond reasonable doubt. So that is why these cases, in most of the cases, they say merely because there is a complaint, you must not arrest a person and remand a person. That is being discussed in many of the cases right through, but it is being happening. So now, Walaha Hangunu Webe Dhammaratana Thera case is a very important case where Justice Depp is clearly stated to police, don't arrest the person and then remand him, and go to court and remand that. Investigate and find out the evidence, and then only you decide about it. That in Mahanama Tiraratna's case also, Justice Dhiratna has clearly stated, merely because to satisfy the police, the magistrate should not remand the person, because they come and say what the confession said, and then they say, we have come to know, we have gathered not the gist of the evidence recorded, whether the eyewitnesses or circumstantial evidence, that is different thing. But it should be reported and then asked for remand. But here, of course, they produce the confession and say that he should be remanded. In Mahanam Tirakatha's case, that is being discussed. And furthermore, this Kalyani Alvitikala case also, Rohini Marasinghe J has clearly stated, till you correct the evidence, you must not remand a person for the sake of remanding. So that is, the laws are there, and we have again and again discussed these things, but unfortunately some of the police officers, they are not adhere to these things, and they are not being asked to discuss these things, but they do whatever they want. Even for some of the drug cases also, they get the confession and then they show to the media people that he has confessed these things, and show the articles also. without showing those things, it would be useful to produce them before court and let the court decide about the things that are being done. So then the police will do justice to the society. Otherwise, what they do is they take the advantage of this particular section and then go against that and show to the world that these people have confessed. They have a lot of cases again behind them, and now we are going to put him into jail, or this suddenly extrajudicial killing had been done. So that should be prohibited, or we have to do more and more important the things to curtail these things. Otherwise, the police will take whatever they want if they are not going to take immediate action against those people who have done wrong things.
Exactly, and it's also important to note that law enforcement should not be acting outside of the law in order to enforce what they would consider as justice. We have a framework that is in place, and the framework has to be followed, as you mentioned. So we have the laws in place, we just need the enforcement to follow through with it as well. But I'd like to ask you, before we wrap things up, because we are running out of time unfortunately, when it comes to the self-defense aspect that law enforcement that we have seen in recent times, also some extrajudicial killings have been occurring under the guise or under the excuse of it being an encounter killing or a self-defense. How exactly does the Sri Lankan law differentiate between an unlawful and extrajudicial killing and self-defense?
Yes, now as you quite correctly asked this question, self-defense is there not only to normal people, but for the enforcement authorities also. This particular area is there. If they have done it in a legal way to safeguard themselves or some other person, then it is being accepted that it's perfectly right thing. But you have to show them, you have to prove them. That is why we are having this inquest proceeding. Merely because they say that we use our right and then we shot at him, that does not mean that the court will going to adhere to. This Fatima Shamila's case, we discussed the case, that is also where clearly stated that we went with him to find out or to in search of the weapons, and then he tried to attack us, and then to safeguard as of right, the right of private defense, we shot at him. So the Supreme Court has said, no, you have wrong and you have done wrong thing. It is not clearly mentioned in that way. Your notes are wrong and you can't kill a person like that. So if the person goes with authorities, and necessary precautions should be taken before they go out. If they know that he is a person of criminal background, they can't just go with him as and when they want, and then allow him to go further and find out and do whatever they want. They have to take precaution. Precautions being not self-defense, and shot at him. So to avoid those things, a lot of areas are being covered now, and police have all the authorities to do that. And I see that my personal view is we have to change the attitudes of some of the police officers, and by doing so we can have a good police department and do justice to people when they are being harassed, or when there is a crime being reported. They can go there immediately and investigate the matter and get necessary important evidence. Especially now we have mobile phones, CCTV cameras, and then a lot of DNA that is also there. So it is very easy for them to take immediate action and take precautions without doing unnecessary illegal thing. So that is why they have clearly stated you have all the new material with us, not on early days they don't have those things, but here we have lot of new technology. So because of that we do with these things. And furthermore, finally I should say, now we have developed not to take these people into courthouses regularly. They are being kept in a special security area in a remand prison, and through Zoom they can participate for legal proceedings. It's been done in Court of Appeal. It's in all cases it's been done, and most of the magistrate courts also, the magistrates through Zoom, they extend the remand prison, and if they have any grievances they can inform court through Zoom. And then even the trial cases, there is a small lacuna. Because of that, 7th of January 2025, new amendment had been gazetted, but unfortunately it has not come up to Parliament. We hope that it will come, and then in most of the cases where they say these people are remand back, a lot of criminal background, they should be kept in a separate place. Now it's been done, and now how they are going to participate for cases also. Now there is a law particularly with regard to criminal procedure code. We are going to have a new amendment for that purpose.
Exactly. So we can see that there are developments in the law that are hoping to better alleviate any sort of grievances that we can see come about due to maybe logistical issues as well. Now Zoom is also being implemented. So we can, in a final comment, sir, can we be hopeful for the development of this current area? Do you think that we'll see an optimistic change in the right direction?
Yes, we hope that because of these regulations are being done, and as I told you, if we are going to provide them latest technology to the police officer, then they will think that we have the particular areas to be covered, and we must not go with the people and try to shoot these people. So to avoid that, we have given them all the necessary guidelines, and the equipment also should be provided. Most of the police officers, they should be provided those latest technology, and then if they are being done, we can see lot of people are being convicted if they are in a position to come out with concrete, cogent evidence before court.
Exactly. I think that's the perfect note for us to unfortunately have to end our discussion. I believe our viewers had quite a bit of an understanding brought to them and clarity brought to them related to extrajudicial killings and also police powers in relation to the current context as well. Thank you very much, sir.
Thank you very much for inviting me. I'm happy that this is a popular program, and I've been allowed to discuss this matter. It is very important to the viewers who are there in this particular program.
Thank you, sir. All right, well, we'll leave you tonight with the words of political philosopher Montesquieu. There is no greater tyranny than that which is perpetrated under the shield of the law and in the name of justice. That's all we have for you tonight on Law, Land and Liberty. If you had missed any of today's programs, you can always rewatch by catching us on our YouTube channel, youtube.com/Derana English. Thank you very much for watching. Have a good night.